This is the third video lecture on the topic of arrest of person under the Code of Criminal Procedure Code. Criminal Procedure Code Chapter 5 contains various provisions relating to this topic of arrest of persons. So far, we have discussed this topic in two parts, and this is now the third part. So, before watching this video, I request all of you that please also watch my earlier two parts on this topic of arrest of persons. Section 41B, capital B, its heading is Procedure of Arrest. What it says: every such police officer who is making the arrest must bear upon his uniform dress an accurate and visible identification of his name, which will easily facilitate the identification of that officer. So, the officer who is going to arrest, he must bear on his uniform some nameplate which will facilitate the identification of that officer. While making the arrest, that police officer must prepare a memorandum. Memorandum of such arrest means how such arrest is made. It is to be noted in writing where such arrest is made, at what time such arrest is made, for what purpose or on what grounds, for what reason such arrest is made. It is to be noted down. And while making such arrest, if any family member of such person arrested is present there, then such memorandum must be attested by such family member. Suppose police officer is arresting that suspected person from his house, then if suppose there is any family member, then that memorandum must have to be attested by that family member. Otherwise, such memorandum of arrest must have to be attested by at least one such witness who is a respectable member of that locality where such arrest is made. If arrest is made somewhere outside, then in that case, that memorandum of arrest has to be attested by any such person as a witness who is a respectable member of that locality where arrest is to be made. Besides, in that case, the police officer must also tell the person arrested that he has right that a relative or friend named by him has to be informed immediately about his arrest. Means, while arresting such suspected person, police officer has to tell that suspected person that it is your right that the information regarding your arrest can be given to any such person, that any such of your relative or friend named by you. It is your right. So in today's part, we are concentrating mostly on the rights of the person arrested. So this is very important provision. Then section 41D, clause D. Its heading is right to meet an advocate. After the arrest, when any such person is interrogated, that is arrested person, when any such person is interrogated by the police officer, then at that time such person arrested is entitled to meet an advocate of his choice during such interrogation. So especially when such person is taken into the police custody and during the interrogation of that person arrested, it is a right of that person arrested to meet an advocate of his choice. Then This is also important right. Then section 50. Its heading is person arrested to be informed of grounds of arrest. Grounds of arrest. As soon as the person is arrested, the police officer has to communicate immediately to such arrested person about full particulars of the offence for which he was so arrested. Besides, other grounds of arrest must also be communicated to such person. So, on the accusation of which offence such person is to be arrested, it is to be informed to that person arrested, grounds of arrest. And where such person arrested is not accused of any non-bailable offence, when such person arrested is not accused of any non-bailable offence, it means it is a bailable offence. It means it is a cognizable offence and bailable offence. It is cognizable offence, therefore police is arresting such person without warrant. But it is at the same time bailable offence. In such situation, police officer must inform to such person that he is entitled to be released on bail, and so he can make arrangement of the sureties for the purpose of bail. So police officer has to tell that person arrested that even though we are arresting you without warrant because you are accused of commission of cognizable offence, but then also this particular offence is bailable offence, so you are entitled to get released on bail, so you make arrangement for sureties, that is securities, furnishing securities for the purpose of bail. Then next section is section 50A. 50 capital A. Its heading is information of arrest to nominated person. Information of arrest to nominated person. So, as soon as the person is arrested, the police officer has to immediately give information about such arrest to such of friends or relatives of the person arrested as so nominated or told by him for the purpose of giving such information. So, we have seen that it is the right of the person arrested that police officer must tell that person arrested while making arrest that it is your right that information regarding your arrest can be given to any of your friend or relative named by you. So here actually police officer, suppose that arrested person gives the name of one of his family member, say for example father or brother, then police officer has to immediately give such information about such arrest to such father or brother of the person arrested. So this is very important provision. After the arrest, as soon as the person arrested is brought to the police station, the police officer must inform or tell such person that he has right that the friends or relatives as so nominated by him to be informed about his arrest. So we have seen this point. After informing accordingly by police officer, the police officer must make an entry about the fact as to who was so informed in the book kept in the police station for that purpose. And such entry must be made in such manner as so prescribed by the state government for that purpose. So there has to be some record in black and white. So one register has to be kept in the police station, and in that register entry is to be made by the police officer that to whom the information of arrest of such person is given, whom, when, to whom given, so all those particulars. And when such arrested person is brought before the magistrate, that is judicial magistrate, then it is the duty of the magistrate to ask such person whether the police officer has told him about his right that his friends or relatives to be informed about his arrest. Accordingly, the magistrate has to satisfy himself about the fact whether or not there has been proper compliance of the requirements under this section 50A, which provides important right for the person arrested. So when that arrested person is brought before the magistrate, magistrate has to ask such person whether the police officer making arrest has informed you that it is your right, that the information as to your arrest is to be given immediately to any of your friends or relative named by you. And magistrate has also required to see whether there is a proper compliance of this requirement. Then Section 54, examination of person arrested by medical officer. This section 54 is for the benefit of person arrested. Examination means medical examination of the body of that person arrested, and this section is particularly for the benefit of the person arrested. So when any person is arrested, then he shall be examined by the medical officer who is in the service of the government. After the examination, the medical officer must prepare the report mentioning therein the marks of injuries which are there upon the body of such person arrested. So medical examination of the body of that person arrested, that medical officer has to check whether there are any marks of injuries on the body of such person arrested. Copy of such report must have to be furnished by medical officer to the person arrested or to such other person who is so nominated by the arrested person for that behalf. So copy of that report of medical examination must be given to the person arrested, or otherwise it must be given to any such other friend or relative which is nominated by that person arrested. Here medical examination under this section 54 is generally made for the benefit of person arrested, so that he could also lead the evidence for defending himself. So such medical examination of his body would offer some evidence which may prove that such arrested person has not committed any offense, but which may prove that some other third person has committed some offense against the body of such arrested person by showing the injuries upon the body of that person arrested. So this section is for the benefit of person arrested. Then Section 55A, capital A, its heading is health and safety of person arrested. This section imposes the duty upon such person means police officer, who is having the custody of the accused person after the arrest, to take reasonable care regarding the health and safety of such person arrested. So after the arrest, in whose lawful custody such arrested person is there, it is duty of that person having custody to take all care regarding health and safety of such person arrested. So we will stop here, but we will continue this lecture in our next part also. Thank you.